Assalamualaikum and very good morning to Prof. So today I would like to present about my case, which is Kesatuan Executive RHB Bank versus RHB Bank Berhad. Okay. So firstly, the facts of the case is on 11 December 2013, the union submitted their form recognition to the respondent bank, but they have refused to grant the recognition and the matter pending appeal at the Court of Appeal after High Court affirmed in the Honourable Minister's decision. Then the respondent bank was ordered to grant recognition to the union. And then on 18 December 2013, Encik Wan Putra, which is the employees from the respondent bank, didn't allow the employee to call any officer from the union to represent him. On 15 January 2014, the court emphasized the respondent bank had violated the principle of natural justice when it denied the employee the right to be represented by the union official at the domestic inquiry that was to commence from the date onwards co-official of the union. So the issue of the case is firstly, the recognition of the union. The respondent bank refused to recognize, which is I just said just now. They refused to recognize the union, which is Kesatuan RHB Bank Berhad, despite the decision of the Honourable Minister of Human Resource granting recognition under Section 9 of the Industrial Relation Act 1967, which is they don't want to recognize Encik Wan Putra and they deny that Encik Wan Putra is under trade union. And then the union also argued it has been legally registered and granted recognition. That's why Encik Wan Putra enabling it to represent its members. But then bank still argued with the union because bank said the respondent bank said that Encik Wan Putra cannot be represented, but the union argued that Encik Wan Putra had been legally registered and granted the recognition. And then union representation at domestic inquiries, which is the respondent bank denied the union official the rights to represent its members, Wan Putra, at a domestic inquiry on the basis that recognition of the union was still under appeal. So, next is principle of natural justice, which is court had to determine whether the bank's refusal to allow the union representation during the domestic inquiry breached this principle. The court has been determined, which is what the bank respondent said is already breached this principle, because actually Encik Wan Putra have the right to be represented at the domestic inquiry. And also next, status quo argument by the bank. The respondent bank claimed that allowing union representation during pending appeal could be construed as recognition by conduct which might prejudice its legal challenge against the Honourable Minister's decision. And then next is impact of limited recognition. The union argued that its registration and limited recognition enable it to act on behalf of members in grievance issues, including domestic inquiries, even though the requirement of trade union said that it is limited to the Peninsula Malaysia, Sabah and Sarawak, but it enable to act on behalf of members, which is to protect the members' right in grievance issues, including the domestic inquiries that Encik Wan Putra experienced. So, the judgment of the case is, firstly, at the material time, the union was a registered trade union and had been accorded recognition by the Honourable Minister under Section 9 of the Industrial Relation Act 1967. So, Encik Wan Putra was officially registered and recognised by the trade union, which is the recognition by the Honourable Minister. And then next, Section 9, bracket 5 of the Act provides that such recognition shall be deemed to have been accorded by the employers from the date specified by the minister, which is in this case was in 11 December 2013. Supposedly, Encik Wan Putra has been recognised under trade union on 11 December 2013. On this case was started. And then next is by refusing to allow union officials to represent the employee in their official capacities during the domestic inquiry, the bank breached the rules of natural justice and committed an unfair labour practice, which is the company treat their employees unfair because they didn't allow Encik Wan Putra to be represented, and they refused that Encik Wan Putra is under trade union. The court allowed the union's claim and then reinforcing the right of trade union to represent the members in grievance and disciplinary proceeding under Industrial Relations Act 1967. So from the case, we can analyze that legal recognition of the union. The union was legally registered under the Trade Union Act 1959 and recognized by the Honourable Minister under Section 9 of the Industrial Relations Act 1967 on 11 December 2013. And then despite this, the respondent bank refused to acknowledge the recognition, claiming that the matter was still under appeal. That is the analysis that we can see from the case that I already explained just now. The other one is limited versus full recognition. The union claimed limited recognition by virtue of its registration, which allowed it to represent members in grievance, even in the absence of full recognition for collective bargaining. Even though under trade union say that it is limited, but it still have the right to be to protect the employees' right and to represent the members in grievance, even in the absence of recognition. And then, whether limited recognition under the trade union and IRA should be sufficient for unions to exercise representational rights at domestic inquiry. Next, principle of natural justice, which is the respondent bank already crossed the line or already violated the natural justice by preventing the union from representing its member, because officially Encik Wan Putra has been registered under the trade union and they didn't recognize it. They refused to give the union to represent him. And a fair inquiry demands that employees are allowed representation to ensure impartiality and fairness in disciplinary action. From this, we can say that denying representation undermines the balance of power between employers and employees, particularly in situations involving disciplinary action. Next, employers' defense. The bank argued it was preserving the status quo pending the outcome of its appeal. It relied on precedent like Dynamic Plantation BHD, arguing the action implying recognition could adversely affect the appeal. Even though there has the limitation, the court has the right to protect the members' right and follow the rules and regulations. So, the critique we can see here is failure to administer decision, which is the respondent bank still argued that the members is not registered and didn't recognize him under the trade union. Then the misuse of status quo argument. The bank reliance on maintaining the status quo reflect on tactical delay rather than genuine concern about the legal implication of the recognition. So this may approach risk being perceived as unfair labour practice. Next is need for legislative clarity. The case exposes uncertainties in the distinction between limitation, recognition and full recognition of union under Malaysia labour law, which is we already know that it has been limited recognition and also we have full recognition. But clearer legal provision of guidelines could help avoid similar disputes in the future. Next is court's firm stand. So we can see here that the court's decision is to prioritize the principle of natural justice or to protect the rights of the members, and then it reinforces the importance of employees' rights in disciplinary proceeding and upholds the role of union in protecting this right. Even though the respondent bank argued with the court or with the members, they still protect the members' right because under trade union we have the right to protect our members that has been registered and recognized under the trade union. Also, lastly, impact on industrial harmony. By denying union representation, the bank created unnecessary friction with the union and its employees, contrary to the objective of the Industrial Relations Act, which aim to promote industrial harmony. So that's why industry or any company need to be fair on their members so that it can create and promote industrial harmony rather than to be seen as unfair industrial. So I think that's all from my presentation. Thank you.